Did special counsel Robert Mueller improperly use attorney-client privileged emails from the Trump transition team? Well, it appears that he did. But I'm going to cut through the fact and the fiction coming from both sides. Well, by now you've seen the story. Lawyers for the Trump transition team, which is now called Trump for America, most notably attorney Corey Langhofer, are claiming that special counsel Robert Mueller improperly obtained emails from the General Services Administration that were being stored for the Trump transition team. And that's where the story starts. So let's first debunk all of the bad information coming from both sides. From the right, they're saying that the Mueller's team had no right to those emails because they were Trump transition emails and they were after the election. Therefore, he was investigating Trump-Russia collusion during the election and the emails are irrelevant. That's what the right is saying. And that Mueller had no right to the emails in any situation, any case, any way, shape, or form. That's on the right. On the left, they're saying Mueller had full right to the emails because those emails were maintained on Government Services Administration, GSA servers, and because they were on GSA servers, they were the property of the federal government, and they're posting all of these terms and conditions from the GSA, and because Mueller is an investigator that was appointed on behalf of the federal government to look into Trump-Russia collusion, he's allowed to look at those emails no matter what. Well, both sides are very, very wrong. Let's start with why the right is wrong. The right is wrong because Mueller obtaining the emails in and of itself is standard investigative practice. If I were on Mueller's team, I'd want to see the emails as well. You want to see all information pertinent to an investigation. So that's where the right is wrong, saying that it's egregious and wrong and dirty in and of itself for Mueller to even have tried to obtain the emails. The right is wrong there. Sound investigative practice to try to obtain the emails legally and lawfully. We're going to get to that in a moment. The left is dead wrong in saying, well, they were on GSA servers, therefore the property of the federal government, and Mueller had every right to them. Dead wrong, because the Presidential Transition Act, as well as memos generated by the Chief Records Officer of the United States government, made and make it very clear that presidential transition team communications and records are held to a much different privacy standard. They are the property of the presidential transition team, now called Trump for America. Any waiver of that information being released or privileged information contained therein must come from the owner, who in that case was the transition team, Trump for America. That was never done. Now, the Trump transition team owned those records. The GSA did not. The people that are putting out these images of GSA terms and conditions are really misunderstanding what they're putting out there. Those terms and conditions, well, they pertain to GSA, Government Services Administration employees. If I'm a GSA employee and I make an off-color joke, maybe it's a racist joke, maybe it's a sexist joke, maybe I'm talking about the commission of a crime, maybe I'm talking about using drugs on the weekend on my GSA email, well, no warrant is needed. I'm an employee. When I sought employment and when I signed my employment paperwork, I acknowledge that any email communication on their servers, on any texts I send from a cell phone the government might give me, is the property of the government and can be used against me, whether to fire me or civilly sue me or criminally prosecute me. So that's where the left is wrong. The Trump transition team were not employees of the federal government. The GSA was simply lending them equipment on which to communicate, on which to store their data until they were moved into the White House during that short transition period. The equivalent, and I'll give you a very simplistic equivalent, is you rent an apartment. You rent an apartment that's owned by your landlord, but everything in the condo and entry to the condo is under your control. The apartment is under your control. Your landlord can't enter and give away your furniture, your television set. Your landlord can't give the police consent to enter your dwelling, your home, without a warrant or your consent. That's what happened here. The presidential transition team, now known as Trump for America, never gave consent for Mueller to obtain the emails. Now, could Mueller have gotten a warrant? Sure, we don't know if that's the case, but it would have been relatively easy for Mueller and his team to say, well, we've already got charges pending against General Michael Flynn for an interview that happened during the transition, Your Honor, so we have probable cause to believe there might be pertinent information, material information in the transition emails. Can we please have a warrant? That would have been fine. So merely obtaining the emails, providing it was done legally. Now, if Mueller went to the General Services Administration over to GSA and strong-armed them, or GSA willingly gave Mueller the emails, well, that's very problematic because they weren't GSA's to give and they weren't Mueller's to request. That would had to have been done with the express consent of Trump for America what the transition team is now called. They would have had to have said, sure, you can have those emails. But so the emails themselves, if they were obtained legally, are not the problem. If they weren't, they become a secondary problem. The real problem here is what Attorney Langhofer is claiming, that Mueller's team inappropriately, improperly, and potentially illegally never notified the Trump transition team, now the Trump administration, or their attorneys, that attorney-client privileged emails were among the emails requested from GSA or provided by GSA under warrant, and that those attorney-client privileged emails were not quarantined. They were not firewalled. They were read and they were reviewed by Mueller's team. Now that's a dagger in the heart of our judicial system. That's a dagger in the heart of due process. If you can't expect confidentiality when communicating with your attorney, well, that's a very, very big constitutional problem. Now, there are those armchair lawyers on the left who say, well, privilege isn't absolute. There's a crime fraud exception. Look up the crime fraud exception. Well, there is something called a crime fraud exception, but that pertains to you communicating with your lawyer with the intent of getting out of a future crime, or your lawyer co-conspiring with you to help you get out of a crime. It's not. The crime fraud exception, rather, doesn't apply. If your lawyer gives you advice and says, okay, you're going into a meeting with the FBI, you're required to discuss this. However, statute and case laws say you're not required to discuss this, so you can certainly refuse to answer that question. That's standard, typical lawyer-client advice, which is privileged. But if Mueller's team used those types of conversations to elicit pleas and to strong-arm witnesses and strong-arm suspects, well, man, the entire investigation needs to shut down, and Mueller and his team need to be investigated. Now, Greg Jarrett did an outstanding piece on FoxNews.com where he laid out some of the statutory problems Mueller has. Greg goes on, he first says what I said a little bit earlier. The Presidential Transition Act states that all records of transition operations are private and confidential. Doesn't matter where they reside. Doesn't matter if the servers are owned and controlled by the Department of Justice, by the General Services Administration, by Social Security Administration. Doesn't matter. The presidential transition records are private and confidential. Greg Jarrett then quotes case law. He quotes case law. And the case is United States v. Taylor, 764. Quote, an attorney who receives privileged documents has an ethical duty to cease review of the documents, notify the privilege holder, and return the documents. In other words, when Mueller's team got the emails from the General Services Administration, they were legally bound, once they saw that there were emails, say, hypothetically, between Michael Flynn and his attorney, General Flynn and his attorney, to cease reading that email, quarantine that email, notify Trump for America, the presidential transition team, say, hey, we messed up. We've got this email. We didn't read it. We quarantined it. We secured it, and we're sending it back to you. But Mueller's team never did that. In fact, it appears they continued to read and use those emails. Greg Jarrett says, did Mueller do this? Meaning, did he notify? Did he quarantine? Did he return the privileged documents? Apparently not. He never notified PTT, the presidential transition team, when his staff of lawyers encountered the privileged documents. And he compounded his violation of the law by possessing and accessing them for months. He goes on to say, and I'm going to read you this, it's very important, only the owner of such materials can waive the privilege that protects them. Since the General Services Administration does not, under the law, own the records, only the transition team can make such a waiver. It did not. Remember my analogy. It's the apartment. Your landlord can't give your furniture away. Your landlord cannot let the police into your home to search it without a warrant. And that's precisely what Mueller did. Now, Jarrett, who's a pretty talented lawyer, continues and says, hence, if any illegally obtained documents have been used in the Trump-Russia case, then the results are tainted and invalid. This is a well-established principle of law. Now, he goes on to quote some other cases. Finn v. Schiller. Quote, courts have frequently used their supervisory authority to disqualify prosecutors for obtaining materials protected by the attorney-client privilege. He quotes a statute, 5 CFR 2635.501. Government employees, including prosecutors, are directed to take appropriate steps to avoid an appearance of loss of impartiality in the performance of his or her official duties. And that's precisely what Mueller's team did not do. Now, this combined with that first case, the U.S. v. Taylor, where the attorneys who access privileged information have an ethical, remember that, an ethical duty to notify the privilege holder, to quarantine the information, to return the information, combined with all of the other problems around Mueller's information. Bruce Orr, a DOJ prosecutor's wife, Nellie Orr, working on the Trump-Russia dossier. Weissman, one of Mueller's top prosecutors, telling fired Sally Yates he was in awe for defiance of President Trump. Jeannie Rhee, who worked for Mueller's law firm defending people like Ben Rhodes in the Obama administration in the Benghazi hearings. Peter Strzok, who we know interviewed General Flynn. Peter Strzok, who interviewed many, many people. And now it might turn out that Peter Strzok had access to privileged attorney-client privileged emails before conducting the interviews with the people who were discussing privileged things with their attorneys. This is incredibly, incredibly problematic. This is incredibly disturbing. And that's the crux of the issue. See, the crux of the issue isn't that the emails were obtained, like I said earlier. That's fine. That's standard investigative protocol. I've got no problem with that. But if Mueller's team, on the heels of Andrew McCabe and all of his conflicts of interest, on the heels of Mueller's own conflicts of interest because of his relationship with James Comey, on the heels of finding out that James Comey altered a memo exonerating Hillary Clinton before even interviewing her, and knowing that the president can fire Comey if it's Tuesday and raining and he doesn't like rainy Tuesdays, that he fired Comey because he lied, because he did those things. On the heels of knowing that Peter Strzok sent thousands of anti-Trump text messages to his mistress, Lisa Page, an FBI lawyer, that he spoke about an insurance policy against Trump winning that many suspect to now be the debunked dossier, that he spoke about being the only person in a position to protect the nation, I'm paraphrasing, who could stop Trump. On the heels of all of that impropriety, to find out that lawyer-client privileged emails might have been read and utilized by Mueller's team, this is far and away the dirtiest investigation I've ever come across. And I've been in law enforcement, in the private sector, working with law enforcement or analyzing law enforcement on air since 1992, 25 years, more than half my adult life, more than half my life, most of my adult life. I have never seen anything this bad. And I'm not saying that because I'm a political partisan. You know my political stance. You know I'm a conservative. I'm very pro-Trump. But I'm also a very objective guy when it comes to law enforcement matters. I started this segment by telling you why the right is wrong. I started this segment by telling you I don't mind that Mueller obtained the emails. That was good investigative tactics. I don't mind that. But because he then accessed privileged emails and he hid that from the transition team. He never got their consent. He never got a waiver. Their lawyers never knew that he was reading their privileged communications. Well, that is about the worst thing I have ever heard someone do. And it's quite frankly terrifying, because if it can happen to a now sitting president and then a president-elect, my God, it can easily happen to you and I without that power, without those resources. But more importantly, Mueller appears to be acting unchecked, unsupervised. It is unconstitutional that any one person should have this much unchecked power. We're a system of checks and balances. But Mueller operates unchecked, and now it appears that he feels he can break any rule so that he can find people who fit the crimes he wants to prosecute. This is really, really important content. Really important content considering all the bad information out there. And I want to keep bringing you these explanations, these clarifications every day. And please help me keep doing that by subscribing to our premium service at www.therebel.media/shows. If you're already a subscriber, thank you very, very much. I'll be back with you tomorrow. Thanks so much for watching.